Good day and welcome to Easy Way School. I am Oboagwina the law teacher. Today we're going to be discussing a very salient topic which is called the overview of corporate law practice in Nigeria. For Nigerians as well as for foreigners who are interested in doing business in Nigeria, this will really ignite the learning of corporate law in you. So what are we going to be discussing? The concept of corporate law in Nigeria is basically classified into two. Number one, the organization, and number two, the stages of incorporation. Now, what are the organizations permitted in Nigeria? We have one, business organization, and we have two, non-business organization. Now, what are those business organizations in Nigeria? These organizations set up to engage in business, and in return, they make profits. To simply say, they are profit-oriented organization. Now, what are examples of these profit-oriented organizations? Number one, all companies in Nigeria. Now, by Section 21 of the Companies and Allied Matters, as amended, Act 2020, it clearly states that we have 6 types of company. So, all 6 types of company are business organization. Now, let me give you a list of these 6 types. We have number one, private companies limited by shares. Number two, public companies limited by shares. Number three, private company limited by guarantee. Number four, public company limited by guarantee. Number five, private unlimited company. And number six, public unlimited companies. So these are the 6 types of company, and all of them are business organization. We also have limited liability partnership. We also have limited partnership. We also have sole proprietorship, and we also have partnership. It is important to note that one of the new innovations of the Companies and Allied Matters Act of 2020 was the recognition of 2 more organizations, which are limited liability partnership and limited partnership. So that's what it means, is that Nigerians as well as foreigners can now incorporate a limited liability partnership and as well as a limited partnership. So please take note of this creation. Now, having said that, what are non-business organizations? These organizations that do not do business, neither do they make profits. An example of these are incorporated trustees. So incorporated trustees are a perfect example of non-business organization. Now, having said the organization recognized by the Companies and Allied Matters as amended Act of 2020, it is important to take you through the stages of incorporation. Now, with this, you understand the very scope and length of corporate law practice here in Nigeria. It is important to note that the stages of incorporation are classified into 3. We have 1, the pre-incorporation stage. We have 2, the post-incorporation stage. And we have 3, the dissolution stage. Now, what you need to learn in each of these stages is what transpire and what should I expect from each of these stages. So please kindly listen. Now, one of the things you should expect from pre-incorporation stage is that at this very stage, the organization is yet to be incorporated. So they have not yet commenced or obtained the relevant document from Corporate Affairs Commission before they start up or commence the activity for which they ought to be incorporated. Now, for companies, it is important to note that proposed members who are desirous of forming this company are called subscribers. So when a company is yet to be incorporated or formed, the right accolade to give to proposed member is the title subscribers. Now the question is, where should the name of the subscribers be entered? The names of subscribers are often contained in a document called Memorandum of Association. Now, what are the agendas you see occur at the pre-incorporation stages of corporate law? Number one is the choice of business organization, where your client decide to make a choice as to what type of organization he or she is to incorporate. So that is one of the things that take place in the pre-incorporation stage. We have number two, formation of companies and other form of organization. Now this is where you engage in the formation of companies. We also involve in promotion of companies, or you could call it promoters activities. And we also have at this stage foreign participation in Nigeria, where foreigners can participate through the medium of foreign direct investments or foreign portfolio investment, which is often referred to as foreign indirect investment. And lastly, we have exemption, which they apply to the Minister of Trades and Investment. Formerly, the application was made to the President, but one of the new innovations by the Companies and Allied Matters Act 2020 is that this application is no longer made to the President, as the application for exemption is now made to the Minister of Trade and Investment. So these are new innovations we have to see, or we have seen so far, from the Companies and Allied Matters Act of 2020 as against the Companies and Allied Matters Act of 1990. Now the next stage we have is called the post-incorporation stage. Now at this stage, the organization is duly incorporated, and one of the proof of incorporation is a document issued by Corporate Affairs Commission. It is clear to tell you that Corporate Affairs Commission, upon incorporation, issued two different forms of documents depending on the organization incorporated. Now, what are these two documents quickly? We have number one, certificate of incorporation, and number two, certificate of registration. Now, depending on the organization you set up, it determines what document Corporate Affairs will issue. Now, what are those organizations that upon incorporation, Corporate Affairs Commission will issue to them certificate of incorporation? Number one we have is companies. All companies upon their formation, CAC issue to them certificate of incorporation. Number two, limited liability partnership. One of the new organizations which is now recognized by the Companies and Allied Matters Act of 2020 will be issued certificate of incorporation. And number three, incorporated trustees. Now, what is the legal implication of issuing them this document? They are now considered as a juristic person, meaning they can sue and be sued in their corporate names. On the other hand, there are different organizations that are issued certificate of registration by Corporate Affairs Commission. Now, what are these organizations? We have number one, limited partnership. Number two, sole proprietorship. And three, we have partnership. So when any of these organizations is formed, what CAC issues to them is certificate of registration. Now, what is the legal implication of this document? They are not considered as juristic person, but they are often considered as judicial person, meaning that the court recognizes them, but they do not have the capacity to sue and be sued in their corporate name. For example, let's say the well-known business mogul Oboagwina set up a business or a partnership of Odogwu Bitters, and we want to sue Odogwu Bitters. It will be wrong to sue them as Odogwu Bitters. Rather, you will sue them as Oboagwina, trading under the name and style of Odogu Peters. So this is how you sue whenever the organization is issued certificate of registration. Now, having said that, what are the matters you see at this very stage? We have number one, publication of names. Number two, the company's organization keeping statutory books. Number three, they hold several meetings, such as statutory meetings peculiar to public company, annual general meeting, extraordinary general meeting, as well as court ordered meeting. We also see in this stage returns are made to Corporate Affairs Commission. We also see the Code of Corporate Governance. We also see company security. We also see corporate restructuring. We also see insolvency. We also see corporate litigation. So these are what transpire in the post-incorporation stage. Now, the last stage we have is called the dissolution stage. Now, the dissolution stage is where the organization contemplates dissolution as well as winding up. Now, winding up peculiarly is for companies as well as limited liability partnership, the LLP. While after they go through the process of winding up, they contemplate dissolution. But I must say that winding up is not the end of the company. Rather, winding up is considered as the means through which the company comes to an end. The end of the company or the organization is what we refer to as dissolution. At this stage, those who were called subscribers at the pre-incorporation stage and later called members at the post-incorporation stage, simply because upon incorporation, their names are now entered into the register of members at least within 28 days of incorporation. At this stage of dissolution, we refer to them as contributories. Now, why are they often called contributories at this stage? It is very clear that at this stage, members are to make contribution towards the winding up of the company. Now, for company limited by guarantee, one of the features is that upon dissolution, its members is to make contribution of at least 100,000 naira. So by making this contribution, we see the name contributories. So what should be discussed or done at the dissolution stage? We have number one, winding up of company. Number two, winding up of limited liability partnership. We also have the dissolution of limited liability partnership as well as company, dissolution of limited partnership, dissolution of business name, and dissolution of incorporated trustees. Now, lastly, for the organization recognized by CAMA, they are identified by various parts. For example, Part B is for company, Part C is for limited liability partnership, Part D is for limited partnership, Part E is for business name, and Part F is for incorporated trustees. Don't forget, I'm Oboagwina Caleb, and if you want more, please comment on the comment section. Thank you for your time.